Sorry. A very good afternoon to one and all. Welcome to the Nalsar lecture series on constitutionalism. Today we have the pleasure of having with us Mr. Arvind Datar, eminent lawyer, senior advocate and leading author. Sir, I extend a very warm welcome to you on behalf of Nalsar. I would say that Mr. Datar do not require a formal kind of an introduction, as most of us who have studied commercial laws, especially taxation, and when I say taxation, whether by choice or whether by mandate, we have all engaged with the work of Mr. Datar, right? And I sincerely hope our engagement with Sir's work will continue with the GST regime. As we all are aware, the GST is to be rolled out on 1st of July. It holds implications for us not only as consumers of goods and services, but rather also academic interest in terms of the implications of the new regime will have on the constitutionalism and the federal setup of our country. Not consuming more time, I will not stand between you and Mr. Datar, so I welcome you to address this lecture.
Good afternoon to all of you, and belated Happy New Year. It's been almost a decade since I've been planning to come to Nalsar, and finally I made it in 2017. I must apologize to Karthik Chawla and the other people. I kept postponing the program because I am still very, very preoccupied with finishing the third edition of my constitution. And just when I'm almost about to finish, I get a 900-page judgment on entry tax. Analyzing it takes 10-15 days. Just when that is over, the judgment on representation of people act, wrongly called the Hindutva judgment, that comes out, and so on and so forth. Now, they asked me to speak on particularly on GST, in the context of the Constitution of India. And they also suggested that I speak on federalism. Well, I have consistently opposed GST from day one. In fact, Vaidiswaran and me, my friend, and I have been virtually the only two people opposing GST from day one. So much so that, and I don't know who was driving this GST, why it was imposed. Even today, it's my personal conviction that it is a step in the wrong direction, and the country will pay a very, very heavy price in the years to come. There was an agenda to drive this GST. It was first suggested by Dr. Rajachalaya that have a General Sales Tax Act. Instead of having excise duty and sales tax and so on, you have one GST. So there is the romantic concept of one nation, one tax. So you have the wonderful idea that every SSC just pays one tax and carries on his business. But like life, tax is something completely different. I'll come to GST later, but why I said that some people were driving it was that when I started opposing GST, writing so on and so forth, I was deliberately asked not to attend seminars and criticize GST because they said, we want GST. In fact, in one thing, they made the mistake of asking me to speak at a seminar in Bombay, and they called me and said that, would you be doing slides? I said, yes. They asked me, what's the theme of your talk? I said, I'm going to say it's a terrible idea. And they said, please, in that case, he called me the next day and said that we would like to cancel the lecture because Dr. Parthasari Shom is coming and we don't want anybody criticizing the GST, which is really sad because I thought there would be a free flow of ideas. And I'll tell you about my discussions with the PMO's office on GST. So let me get back to the topic on the Constitution and federalism. I'll just come to federalism, and I'm not going to speak separately on the Constitution. I'm just going to speak on very, very briefly on federalism and what an impact it has on GST and why it is my idea that GST is a terrible, terrible idea. See, as far as federalism is concerned, I won't waste much time. if you take the entry tax judgment where I appeared for some parties from Arunachal and from Maharashtra and from Tamil Nadu, there is a small discussion by Justice T.S. Thakur in the leading judgment, and he discusses the basic concept of federalism. And out of the Constituent Assembly debates, you must see only two speeches. One is by Dr. Ambedkar and the other is by Professor Dr. T.T. Krishnamachari on federalism. Now, just to take 2 minutes of it, and I'll go straight into my talk. As far as federalism is concerned, if you see the Constituent Assembly debates, and as you know that we decided to continue with the Government of India Act 1935, right? Instead of having a unitary government, we said let's follow the Government of India Act 1935. And at this moment, I may tell you that all people who say that, you know, that this is a constitution written on tabula rosa and written on things, all not correct. Almost 85% of the constitution is the Government of India Act 1935. You have some additions here and there, but basically it's the Government of India Act. Nothing wrong with it, and our Constitutional Assembly founders made, if you see the debates, they are fascinating and fantastic. And it is really, really very humbling to see the kind of scholarship. We talk of Ambedkar and Krishnamachari, but you must also see the speeches of Sir Alladi Krishnasamy Iyer, Professor Kunzru. Then you have Dr. P.S. Deshmukh and so on. Lovely speeches on that. Now, as far as federalism is concerned, the Government of India Act, when it came in 1935, they had this concept of the federal list and the provincial list. And this was converted into the union list and the state list. One criticism, should I wait for 5 minutes till people come, or? Yeah. No, I'm not in a hurry, you can. Yes. No, let them come and don't stop anybody. I just thought that. The one criticism was that our constitution is too centrist and the states are reduced to virtually nothing. And in a lovely speech by Dr. Ambedkar, he said that this criticism is completely fallacious, it is without substance. And he said that the principle on which our federalism rests is the partition, he uses the word partition, is the partition of legislative and executive powers between the center and the states. So what we have done is, there is legislative power, there is executive power, everything flows from the constitution, and we have partitioned these powers into list 1 and list 2. It may happen that more powers are given to the center, yes. It may happen that the states don't have a residuary power, yes. But nonetheless, it still remains a centrist, it still remains a federal constitution. And Dr. Krishnamacharya also explains that even though you have Article 355, Article 356, President's rules and so on, it does not take away the concept of a federal structure of our constitution. And if you take Justice Sikri's leading judgment in Kesaran Bharati, he settles, he puts 5 things of what's called the basic structure, and the fifth, the last part in those 5 is the federal structure of our constitution is now said to be the basic structure, part of the basic structure of our constitution. Now let me come to GST, which is the focus of today's lecture. And I'll also, while I'm talking about it, I'll start mentioning what are the constitutional implications of GST and go on. And as I was telling the organizers here, that I'll finish in about, say, 35-40 minutes, and I'll leave the thing open to questions. And they also said that give career advice to people. Well, I am slightly allergic to giving advice because Oscar Wilde said that giving advice is bad and giving good advice is fatal. So, keeping that warning in mind, but on a more serious note, you are free to ask me any questions you want on a career in law. I have finished 3.5 decades at the bar, and I have enjoyed every moment of it. There's not a single day in my life where I got up and said, what am I going to do today, you know? And I'm still, and my biggest tragedy is the shortage of time and so much to read. Anyway, so after the lecture is over, you can ask me questions not only on GST, but virtually on every subject, including Trump's speech yesterday. Mind you, it has got a very serious bearing on Make in India, but that's a different story. Now, come to GST. goods and service tax. Throughout the world, except I think Brazil and Canada, most people have a unitary GST. There is one GST. If you go to Singapore, you have a 7% GST. It used to be 3% earlier, now it's become 7% GST. So whether you go and have a glass of beer, or you buy a watch, or you buy an electronic equipment, everything has 7% GST, flat 7% GST. In the UK, in Europe, in the EU countries, it used to be up to 17% was the flat VAT. And everything was covered by VAT. They didn't have multiple VAT. So the first and most important feature of VAT or GST is that it is one nation, one tax. Now what is my quarrel with our GST? Before GST, let us take the principle before GST. What was the situation? One unique feature of our constitution is that there are no taxes in list 3. Your teachers must have told you that there is no tax in list 3. And if you go to the union, the taxes start at entry 81, 82. 82 is tax on income, 83 is tax on customs, 84 is excise duty, and so on and so forth. It goes on. And then you finally come to 97, which is any other item. But then the last item is stamp duties and other things. Similarly, you go to the states, you got from entry 44 onwards, all taxes coming down, right up to entry 62, 63. You got tax on land, tax on buildings, sales tax, entry 54. You got tax on electricity, tax on alcohol, 41 and so on. So in simple terms, the taxing powers have been divided between the center and the states. And the principle which has been laid down is there can be no overlapping of taxes. The other point which I wanted to make, if I get time later I'll mention, is about the absurdity of the aspect theory, which has been wrongly brought into our constitution. And according to me, the aspect theory has no place in our constitution. It's a Canadian concept. And why you support aspect theory? You're laughing. No, she's smiling.
No, we had just a week before, we had this very intense discussion in class where we were like, why is this aspect theory in our jurisdiction?
Yes.
Reminded of that discussion.
Yes, if I may just digress for a minute and finish aspect theory and come back to GST. I hope you don't mind that. We have got what is called the doctrine of pith and substance. Alright? Now, there is a law under list 1, but it may have certain features of list 2. Take a common example. Muthuswamy Goundar's case, federal court judgment. You have a law on money lending. It fixes a cap on money lending. It wants to give relief to people who have borrowed money from usurious money lenders, so you want to put a cap. One argument was that loans taken on a pro note will be outside list 2 because pro notes is a negotiable instrument. Negotiable instrument comes under list 1. Therefore, you can't, a law which affects my rights, create a negotiable instrument, will be coming under the federal list, and therefore it can't come under the provincial list. I'm saying federal provincial because this is a 43 federal court judgment. In an excellent judgment, the federal court said that, look, in pith and substance, this is a law relating to money lending. There is an incidental encroachment because some loans may be taken on pro notes, but that doesn't make it a law relating to negotiable instruments. It continues to be a law relating to money lending. And therefore, in pith and substance, it is the law. Now, for the first time, this aspect theory was brought in 1990 in the Federation of Hotel Industries judgment. Mr. Parasaran, who appeared as the Attorney General at that time, I had a discussion with him. He said that the way Palkala's arguments went on, they were virtually going to lose the case on this concept of luxury tax. So while working on this particular case, he came across certain a Canadian commentary by Laskin. There are two excellent books on the Canadian Constitution. One is Dr. Hogg, Peter Hogg, and the other is Laskin. And in the commentary by Laskin, he has introduced the theory of aspect theory. Now what is aspect theory? If you take the Canadian Constitution, under the Canadian Constitution, there are only two lists. They don't have the third list. If you go to the Canadian Constitution, which is the BNA Act of 1897, Section 91 is the provincial list and Section 92 is the state list, and they don't have any concurrent list. Now the first concept of aspect theory came in 1888 or 1899 by the Privy Council, where they said that a law which is a federal law with one aspect may also be a state law with regard to the other aspects. So it becomes a double aspect theory. Then, for example, there is a one particular case where criminal law in Canada is a central subject. The running of bars, etc., is a state subject. A state law was passed making dancing in improper clothes an offense in bars. Now, could the state government make it a crime with regard to the state law? They have discussed the entire aspect of the aspect theory. Similarly, aerodromes came under the federal list, whereas land came under the state list. Now, can the state government, in the powers with regard to regulation of land, regulate aerodromes? Because aerodrome comes under the central list and this comes under the state list. So then they talked of double aspect theory. This is a law with regard to aerodromes, central federal law, and also a law with regard to the state with regard to this. And then they discuss what is there are two aspects of it, how both can coexist. Now my theory is this has no place in India, because if a law is there, you must just find out in pith and substance what is the law. Is it coming under the state list or the union list? And I lost three cases on this aspect theory. The first time I appeared before the Bombay High Court on service tax on professionals. Service tax on professionals. I appeared for all the architects and so on. It went to the Supreme Court. When it went to Supreme Court, I was stuck up in some other matter. I could not appear. Now, what is this aspect theory? And I'll come to the GST shortly. Just pardon me, but this is important. Tax on professionals is entry 62. Entry 62 of list 2 talks of tax on professionals. It called tax on professionals, trades and callings. That is the entry. Article 276 says, subsection 2, clause 2 of Article 276 says that the professional tax can't be more than 2,500 rupees. There's a ceiling limit on professional tax. Just to tell you, 2,500 rupees was made in 1964 or 65. In the Government of India Act, Article 276 was actually Section 104 of the Federal Act, Government of India Act, and there you could not have profession tax more than 250 rupees. So basically, profession tax is under the state list. Maximum taxes 2,500 rupees can be the maximum tax on a professional. Now they introduced service tax. Now, as you know, service tax by Dr. Chalaya was initially meant to be on important services. If you see the Chalaya committee report, he did not want service tax to go on beauty parlors and so on and so forth. He wanted to go on the major services. Now, service tax kept on being extended. As you know, from 1994, they kept on having services. So by 2011, they had services on some 146 items. And finally, there is a limit to where your mind can think of services, you know. So you have services like passing of goods through pipeline service. That's a service under the Service Tax Act. Like carrying goods in a plane is a service. So they said, okay, let's stop the limits to human ingenuity. They put a negative list under Section 66D. Unless what is specified here, everything is taxable. So basically, our service tax is a tax on contracts. And as I said, somebody said it's a birth to death tax. I want to make a small correction. It's not a birth to death tax because hospitals are exempt and crematoriums are exempt. So after birth and before death, everything is taxable in terms of service tax. In fact, one of my interns or juniors, I told him, what is this negative list? I said, tomorrow they'll tax even crematoriums. So when I die, I'll have to make a provision for this crematorium tax. He goes, sir, clause 10 exempts crematoriums. Anyway, come back to this. So I argued before the court, Bombay High Court, that look, you can't levy tax on professions because tax on professions come under list 2. How can you put it under list 1? And if you take the classic judgment of Dhillon, which is Dhillon's judgment, what does it say? Whatever is not in list 2, government can tax, central can tax in 97. Simple test of 97 is, just see if it is in list 2, it's out of central government, otherwise they can do. Now there's a lovely judgment of Chinnappa Reddy, if you want you can note it down, International Tourist Corporation's judgment, where, yeah, it's a beautiful, it's 81 Supreme Court 774, because we have done so many times. Now that judgment says, take a list in the state list. It says tax on professions. ask yourself the question, can the impugned tax come within that state list? If the answer is yes, the central government cannot tax it. They were talking in terms of motor vehicles tax. Now tax on passengers, it can come under entry 56, is it not? It's a tax on motor vehicles can also include tax on passengers in the motor vehicles, because you all studied in constitutional law, every entry must be given a liberal interpretation, there should be free play in the joints and so on and so forth. All those wonderful statements are made. So I argued that if service tax, a tax on professions is entry 62, you can't levy service tax on professions under entry 97. They came to an ingenious solution by saying entry 62 is a tax on the status of a profession. See, the moment I enroll as a lawyer, I pay tax. I may or may not practice. But service tax, if I earn 1 lakh, I pay 10,000. If I earn 1 crore, I pay 10 lakhs. So this is on the right to carry on profession will be service tax, and this. To my limited brain, I still can't understand the difference. So I just asked myself the question, suppose the Tamil Nadu government said that I will levy, in fact, Justice A.P. Shah was heading at that point. He asked me, how can you say that there is a limit of 2,500 rupees? I said, limit doesn't define legislative competence. Suppose they make it unlimited. Then what happens? Ask yourself the question, can the Maharashtra government say architects shall pay profession tax at 2% of their gross earnings? Will that be valid or invalid? It will be valid. That's one thing where we lost. The other place again we lost was I appeared for all the leasing companies. Now, after the 46th amendment to the Constitution, a lease, a hire purchase becomes a deemed sale, and you have to pay tax on that, because strictly speaking a lease is not a sale, but it's a legal fiction. Now they introduced service tax on leasing transactions also. So I argued that it's already coming on entry 52. How can you put it later? So they said no, there is an operating lease, there is a financial lease, this is on the financial component of the lease. And so now what happens if you go to your leasing transactions, on the EMI, on the interest portion they levy service tax, on the principal portion they levy VAT. But my personal view is India must always stick to the pith and substance and not the aspect theory. In fact, one article of mine which is in preparation for, I don't know, I just got in the sideburn. If you take, there's a, I don't know if you get, if you are subscribing to Westlaw, does your, yes. If you go to Westlaw, there's a lovely British journal called British Tax Review. And we finished in 2011, there's a lovely, we finished 50 years of income tax. And a gentleman from England has written a lovely article on the history of the Indian Income Tax Act. What happened, how the income tax was levied. When the income tax was first levied, there was an uproar in British Parliament. They said, you can't levy income tax in India. And you know what was the Income Tax Act? If your income is above 600 rupees per year, the tax was at the rate of 3%. And if it's below 600 rupees per year, it was 2%. And British Parliament, the debate say 3% is atrocious. People will not pay. It is so heavy, etc. It's amusing. And one English parliamentarian said, don't impose tax in India because it will be planting an English tree on Indian soil. It will not survive. So my title of my article is, the aspect theory is a Canadian tree on Indian soil. It should not be there at all. So this is as far as the aspect theory is concerned. Now coming back to GST. So please think about it, whether you agree with me or not. I think we should stick to pith and substance and not go to aspect theory. Because what they say is, aspect theory is qua the law. Our Supreme Court has made aspect theory qua the contract. I am paying 25,000 rupees for taking a Honda City car on rent. 19,000 is principal, so that is the sales tax aspect. Interest aspect is the service tax aspect. It's not aspect of a contract, it's aspect qua the law and not the contract. But anyway, the limitations of time, I won't get into that. Now back to GST. So earlier what used to happen was, you had excise duty, some central levies, and you had some state levies. Then somebody got the idea that take a company like say Tata Motors, they pay central tax, they pay central excise duty, they pay sales tax, they pay central sales tax. So why not we have one common thing, one GST, and as it is always propounded, one tax, one country, one tax. Then it was referred to the Kelkar committee. They said, okay, keep it GST, but make it 12%. Now, as the years went on, just as a ship gathers barnacles on the base of the hull, Here also GST, a pure concept of one station, one tax, got increasingly corrupted, diluted, mutilated, and so on. Now, at the end of the day, we finally had GST, which is the Constitution 101st Amendment. What is my quarrel with GST and why is it bad in the context of federalism? The basic flaw with GST is that there is not one GST, there are 29 GSTs in the country. We have 29 GSTs because every state can have its own GST, which is called SGST, State General Sales Tax Act. And Article 256A of the Constitution says, Parliament and every state has the exclusive power to levy GST. The only limitation is states can't levy GST on interstate transactions. They can levy GST only on the transactions which take place within their territory. That's the mandate of Article 286. So now what's going to happen is, you'll have Tamil Nadu GST, you'll have Bengal GST, you'll have Rajasthan GST, you'll have 29 GSTs. Point number one. Now, on the concept of federalism, the Supreme Court says that the states are not appendages of the center. States are not appendages of the center. Within their own power scope, they are plenary, they are as sovereign as the others. Dr. Ambedkar said, within their respective spheres, the center and states are co-equal in terms of their legislative power. Now, today you have 29 GSTs. What happens if those GSTs are not in sync? What happens if Dr. Jayalalitha decides to go off on one different tangent, Mamata Banerjee goes on a different tangent, there's nothing you can do about it. Now we got this wonderful GST Council. GST Council has the Finance Minister, the Minister of State for Finance, 2 central representatives, and the Finance Minister or the nominees of each state. So this is the composition of the GST Council, and they are supposed to work and take decisions by 3/4 majority. Today the danger is, if a particular state government decides not to follow what the GST says, there is nothing you can do about it. Nothing. So the first objection to GST is, a GST, 29 GSTs, to call 29 GSTs as a GST is the biggest oxymoron in the world. It's the most ridiculous contradiction in terms. You talk of GST, I can understand Canada, Brazil has dual GST. Canada has dual GST, but we have 29 GST, which is really like a hydra-headed situation. Now that's the first objection I have. Second point which I am making is, as far as GST is concerned, is this multiple rates of tax. The essential feature, if I may use the term, the basic feature of a GST is one tax. At the most you may have 2 taxes. But look at what we have done in our GSTs. There is a 0% rate for essential commodities, medicines and so on. Then there is a 2% rate for jewelry. Then there is a 12% rate for basic items. There is an 18% rate for something. And there is a 40% rate which is called the sin tax. Sin tax is not alcohol and cigarettes, but sin tax also includes motor vehicles, expensive clothing and so on and so forth, because part of the socialist heritage is everybody should be as miserable as possible. Anything which makes you feel nice should be taxed as heavily as possible. That's a fact, because when I was a junior, shampoo was 105% duty, right? So, but if you buy soap from Khadi Gramodyog, 0% duty. So that was the spirit. So coming back to this, on the aspect of GST, a multiple rate of GST is a disaster in the making, is a disaster waiting to happen. Now just look at the scenario, what's going to happen as far as the GST is concerned. And the other thing which in one seminar when I spoke, I said, look, you are debating you must have seen the papers, acrimonious fights are going on GST for so many years. Now this concept of dual control, that's even more ridiculous in my opinion. Now come back to GST. So the first part is multiple GST is bad. Second part is multiple rates of taxation is not unheard of in any part of the world on GST. You go to any country in the world, you don't have 9 rates of tax. Then don't call it a GST. Now, on a practical level, there is no time to speak now. The biggest danger in India, and interact with so many companies and so many multinationals. If you ask me, the biggest stumbling block to the Make in India initiative is the manner in which our taxes are administered. In no other country you have so many absurd interpretations placed on the law. Now you've got transfer pricing, for example, and this has got a bearing on GST. GST contemplates a seamless taxation where people don't waste time with lawyers and chartered accountants, they go on with their business. Transfer pricing, I don't know if you have studied transfer pricing in income tax, but transfer pricing is if you have two enterprises, say Ford India and Ford USA, they are what is called associated enterprises. Now, what happens is, the basic law throughout the world is, you must be knowing what's the meaning of base erosion and profit sharing, BEPS. What you try to do is, the notion is every taxpayer will try to reduce his tax burden. So if I'm Ford India, how do I reduce my tax burden? Tell me. Either I reduce my income or I inflate my expenditure. Get it? Simple way of reducing my, says a lawyer, how do I reduce my income? Either I earn less or I spend more, or of course both. Right? So as an assessee, what I'll try to do is I'll try to increase my expenditure. So when I buy parts from Ford US, I'll pay $25, whereas that's being sold at $15 to other countries. So this is essentially transfer pricing. We try to arrive at a price which is an independent price between two independent persons. That is simple transfer pricing. From 1st January 2016 to 31st December 2016, we have had 426 reported cases on transfer pricing in India alone, which, for your kind information, is more than the rest of the world combined. If I tell you the kind of interpretation which you have placed on taxation, you'll be shocked at the kind of administration. That is the biggest danger for me as far as GST is concerned. How are you going to interpret the law, and nobody will check them in any manner whatsoever. Now, I mean, just to give you some examples of how our laws, tax laws are administered. I've spoken about this in some seminars earlier. The whole difficulty with us, and that's going to be a problem with GST, is all the taxes are revenue driven, are target driven. You tell the officer, this year you must collect 25% more than last year. Last year you collected 100 crores, this year from Hyderabad collected you collect 125 crores. So that's it. To my limited intelligence, if your GDP, if your manufacturing sector is going by 5%, how can you have a 16% increase in excise duty? It's mathematically not possible. All of you understand, suppose my industry is growing at 5%, my excise duty can't grow at 16%. It's not possible. Because excise duty is based on manufacture of goods. So the guy starts making absurd demands. Same thing as far as sales tax is concerned. He starts making completely absurd demands just to raise money on that particular point. Now, just to give some 2-3 absurd examples, and I'll proceed further on this GST part. I just landed in Madras from Delhi, and I got a call at 10:30 in the night saying that there's a very urgent thing. A leading hospital in Madras, the accounts are going to be attached by Monday. Why? Because they got a demand from the sales tax department. All operations are works contracts. All operations are works contract. Why? What's in a works contract? I make an operation. Let's say I have an appendix surgery, and this is the notice in the department. Or let's say I have a knee replacement. The argument is that the surgery is a work. Right? There is transfer of property in goods because that knee continues to be in my body, or the saline continues in my body, and therefore it's a surgery. Attach the bank accounts of the hospital. This is the kind of demand that is made. And even shocking thing is, as far as a large software company, in the large software company, they have got 110 branches worldwide, and the entire software development is done in Hyderabad, Bangalore, Chennai, and somewhere in Noida. Now the model is cost plus model. Right? So if you bill $100 million, the cost, your profit margin is 10%. So if you give me a $100 million project, I will charge you $110 million. All right? So this was the model followed for a number of years. Now one fine assessing officer comes and asks a question. What are you doing? I'm exporting software. Now once I export software under section 10A of the Income Tax Act, all my profits are exempt from income tax. In fact, for you students to tell you on a commercial basis, the biggest reason for the for the software boom in India is section 10A and 10B of the Income Tax Act. They just gave a profit tax holiday of 10 years for all profits made from software exports and certain manufacturing exports. And that's how all these enforcers, Wipro, all boomed, because they didn't pay taxes. But the consequence was the amount of jobs that they developed and so much of spin-off benefits. So now this particular multinational, which does work in 110 countries through India, all its profits were exempt. Now in Bangalore, I have to make a target, I have to meet my target. So catch hold of this multinational which is making huge profits. If I can disallow this benefit, simple. So what do you do to disallow benefit? And this has actually happened, and finally they came to a settlement with the department. He asked that, how do you export your software? He said, through telephone lines, lease lines. Who is your lease line provider? He said, Bharat Sanchar Nigam Limited. Then the AO from Bangalore writes to Delhi and says, do you have lease lines to US, UK, Canada, etc.? He says, no, our lease lines are up to the territory of India, and from there we have a hand-holding arrangement with cable and wireless and AT&T. So from there they take away all the signals. Similarly, on the way back, up to India, the cable comes with that foreign company, then we take over and we do it. So the argument of the assessing officer is, since BSNL has lines only up to the territorial waters, no exports at all your exports are disallowed, demand 600 crores in tax, they threatened to arrest the MD, they had to pay 100 crores by coercion. Now, this is what has happened as far as our concern. Now, why am I making so much of this? You have a GST administration. And my argument was, the fault is not with sales tax or central excise, the fault is how the law is being administered. Now you have GST. Now look at this new model. Again, we have got a unique contribution to world jurisprudence in taxation. Normally, if I'm an income tax officer, I'm governed by the income tax department. But in GST now, as a compromise formula, nobody wants to give up control. What's happening now in GST? Please note one thing before I forget. You must note as far as what exactly GST does. One unique feature which strikes me is there is no legislative entry for GST. Surprisingly, I would have thought GST should be put in concurrent list. But there is no entry for GST in Schedule 7. GST is traces only to Article 246A. Now, hereafter, there is no sales tax, there is no service tax, there is a tax on supply of services and goods. Technically, the legal name for GST is a tax on the supply of goods and services. That's the meaning of GST. So, what is happening now? Take the case of Tata Motors, let's say. You're buying a Tata truck. Before the GST regime, when I manufacture the truck and I sell it, I pay excise duty. I also pay sales tax on the truck. Now this again brings you to the aspect theory and the pith and substance theory. The argument for the federal court was, I sell a truck for 50 lakhs. You levy excise duty on 50 lakhs. You also levy sales tax on 50 lakhs. Are you not taxing it twice? And in a very lovely judgment, CP and Datar, they said no, there are two features of a tax. The taxable event is most important and the measure of tax. When I manufacture goods, excise duty is on the manufacture of goods. So I pay excise duty on manufacture. What is the measure of excise duty? What is the value of excise duty? I can take it as sale price. I can also say trucks above 10 ton will pay 2 lakhs. Trucks above 50 ton will pay 25 lakhs. When I was a junior, in refrigerators it was based on cubic capacity. On motorcycles it is based on cubic capacity. 100cc bike so much, above 100cc so much. So that's all on value. But the tax is on manufacture. So in taxation, remember the two cardinal principles of taxation are subject matter of tax and the measure of tax. So excise duty subject matter is manufacture, the measure is the selling price. Sales tax, the subject matter is the sale, transfer of property in the goods, because mind you in excise duty, the moment I manufacture, I am liable to pay excise duty, even if I don't sell it. Even if the goods are unsold, you have to pay excise duty. There is an exemption provision, but in law you have to pay excise duty. Whereas in sales tax, I have to pay only when I Sell the truck. If my truck is unsold and lying in the godown, there is no sales tax. There, what's the taxable event? The sale of goods. What's the measure of tax? Again, the selling price. So measure can be anything. Like in land and buildings, the tax on land can be based on your rental value, it can be based on the capital value, it can be based on the area in which you are living. So subject matter is different, measure is different. Now come to GST, Goods and Service Tax Act. It's a tax on the supply of goods and services. So when tomorrow after GST comes into force, when a truck is sold to you, they will charge, say, let's say 18% of GST, which will be a combination of excise duty, sales tax, service tax, all put together. That's why it's a combination of all these taxes. Now, what will happen is, if the truck is sold in Maharashtra, suppose the truck Tata is made in Pune, it's sold in Maharashtra, it will suffer only state GST. If the trucks are sold outside Maharashtra, they will suffer CGST, which is called Central General Sales Tax Act. This is how the entire structure goes. So as far as our constitution are concerned, there is a merger of excise duty, service tax and sales tax into one tax, which is called the GST. Now, the story doesn't stop there. Has excise duty gone? No. Has sales tax gone? No. On what will be excise duty? Excise duty is entry 84. Even today, you will continue to have excise duty on petroleum products. Petroleum products are outside the scope of GST. Similarly, in sales tax also, the states have given the power to exclusively levy sales tax on petroleum products. So, as far as the constitution is concerned, excise duty is gone on all products except 3 or 4 items, that is tobacco, alcohol, and tobacco, industrial alcohol, and petroleum products. Sales tax also will be levied on these particular products. So now you have SGST, you have CGST, IGST, excise duty, sales tax, and octroi continues. Octroi is for local taxes. They have got certain powers to levy entertainment tax and amusement tax. So this myth of one nation, one tax is completely bogus. There is no one nation, one tax. What we are having basically is the old VAT system, the old excise system partly amalgamated, and the other system continues. The other objection to our Indian GST, which has been, they tried their best but they could not succeed. Today in large parts of the country, fortunately power situation is better, but in many factories, fuel cost is a very important cost of manufacture, because there is no power. You have your captive generation plants. But for some reason they have kept diesel out of GST. So what happens is, the idea of a GST, basically what is the economic principle of GST or VAT? You avoid the cascading effect of tax. Whatever tax is paid on the input will be set off against the tax payable on the output. Suppose I make a truck with glasses, with windshield, engines, etc. Whatever duty I pay on the inputs will be adjusted against the duty payable on the final truck, right? So basically you don't pay duty on duty, you only pay duty on the value addition between each item. I buy tires, I buy windshields, I buy this, I assemble full truck, so I pay tax only on the truck after getting set off of these duties. But now what's going to happen is, when Tata makes a truck, whatever diesel is used will not get credit. In real estate, is completely out of GST. I applied for this CRIDA, Construction Association, we made representations and so on. But for some reason, the government refused to bring the entire building sector into the model of GST, whereas throughout the world, real estate also is in GST. So suppose I build this building, the contractor builds this building. Now, whatever inputs are there, he does not get any credit at all. So that becomes cost, and mind you, in construction, they have noted in terms of data, if you buy a house for 1 crore, on a rough ballpark figure, 38% represents tax, with stamp duty, this and so on, and there is no set off for that. So this is the aspect of GST. Now, to conclude my point, GST, of course, is a major change. And I've written quite a few articles in Indian Express criticizing GST. In fact, in theory it sounds very nice, you know. Take a large company. It doesn't have to pay excise duty, it doesn't have to pay sales tax, doesn't have to pay service tax, it just pays one tax and it's so nice and convenient. But I said the reality is completely different. In fact, my colleague, we are making a study. We find that the number of returns you're going to file is going to be much more, procedure is going to be much more difficult for smaller units. It's going to be a big hassle. My other fear as far as GST is concerned is the massive kind of tax evasion. Now talk of demonetization. H.L. Mencken, the American satirist, once said that for every complex problem, there is a solution which is simple, neat and wrong. Right? So you wanted to do demonetization. It definitely was important because it helped check terrorism and so on and so forth. But look at the amount of extensive collateral damage. You're a society which is completely, basically cash driven. I was talking to the director of Glaxo in Delhi the other day, and he told me that for the first time in 55 years or 56 years, the Horlicks factory in Naba closed down because of demonetization. There was no cash. Because once the Horlicks is sold by Glaxo to the distributor, thereafter the entire economy is cash. Manufacturers of jeans, a well-known brand, completely shut down for two reasons. Because entire market after the wholesale distributor is cash. The other reason is 35-40% of the labor is daily labor because of labor laws. If they make them permanent, they can't afford the overhead, so they keep them going on a daily basis. All are paid in cash, no money in the market. So 40% of the labor did not get jobs for 2 or 3 months. So there was extensive collateral damage as far as demonetization is concerned. You put it on people, it had good points, but it can have far worse points. The point I'm trying to make is demonetization has very, very important lessons for GST as far as India is concerned. Today, everybody has to migrate. The word is GST migration, is the new buzzword. GST migration is the most important thing. All have to go into an electronic system. Ask yourself the question, who's going to come into GST? As of now, anybody more than a turnover of 15 lakhs or 20 lakhs. What's the limit? I don't know what they finally decided. 15, 20 lakhs. Let's assume it's 25 lakhs. 2 lakhs per month. If your turnover more than 2, 4 lakhs, you come into GST. Ask yourself the question, how many traders in India have the technical capacity to have a computer, put all these returns, load them and have into a simple form? In Madras, in Chennai, they had this notion of, suddenly they get all these, what you call, now I can't say jhatka, but suddenly a kind of an impulse. Let's go electronic, the digital India. So Tamil Nadu government said, hereafter all your interstate transactions has to be on C-forms. And we will be a paperless state. We will not accept C-forms and paper. Upload it onto the computer. Wonderful. But the software was so slow that a company like MRF, they have something like 300, 400 CST C-form transactions per day. And it found that the machine was taking 40 minutes to upload one C-form. So just imagine what happens. And what did the department do? Since you did not upload the C-form that day, were disallowing your entire sales tax, pay 12%. Now the point in GST is, please remember my lecture and let's see if you will remember 1 year later that whether what I said was true or not. All across the country, you're going to have people forced to enter into GST, forced to operate computers with a system where power is not certain. Do you know in these ATM machines, especially you go to eastern, northeastern state, eastern UP and Bihar and so on, because a relative of mine is in the banks. You press your thing and the power goes off. After you come back, you have to redo it. There's a loss of 800 crores for State Bank alone on this particular account, on this mismatch because of power failure. Now, when you're going to go to GST, you're going to have tremendous amount of problems because of the lack of infrastructure, technical capacity for a person to do it. So it's like saying that all of you will start running the 42-kilometer marathon from tomorrow, migrate to the marathon mode, start running. Now, if you're not fit, you're just going to collapse halfway. And I fear there's going to be a huge backlash because most people are completely not ready for GST at all. You're going to have a major problem because some of your inputs will have 12% duty, your output will have 18% duty. How do you match the credit? Today C-forms are not available for 2 years at a time. Where are you going to get the inputs, all the inputs? And the very funny thing as far as the thing is concerned, suppose tomorrow I buy this computer, I pay 18% duty, I'm entitled for GST, again another thing. Now, unless my computer dealer pays 18% and sends me proof, and I furnish the proof, I can't get GST. Can you imagine how ridiculous? You see, you don't, since you're not practicing tax, you do not know how impractical the situation is. I buy a Toshiba laptop. Now, how does one lawyer in Madras or Delhi get the proof from Toshiba that he paid the thing, and till I get that proof, I can't claim my credit? The other dangerous part is, if they find that Toshiba has under-invoiced its computer, my credit will be disallowed. Now, what do I know what Toshiba will do? So these are all practical problems which are going to be horrendously complicated in the years to come. When I wrote these articles, I was asked by somebody in the PMO that you are writing against it, what is your problem? The statement given to me was that, look, we can't go back on GST. We announced it to the world. It is impossible to backtrack now, and GST has to come. If GST has to come, what is your suggestion? So, I think they called me because I was the only person criticizing with my colleague Vaidisuran. So I told them, I said, look, my suggestion is, if you are determined to do it, fine. And I said, as a citizen, once the majority in Parliament has voted for GST, I will do my best to support GST in whatever way I can, because that's the principle of democracy. Even if you are in the opposition, once the resolution is passed, then all of us must work for the nation. My simple suggestion is, please don't roll out GST at one go for all sectors. When Model Act came in 1986, it was recommended by Mr. L.K. Jha, who was then Governor of Kashmir. They first started Model with 37 items, then 67, then 94, then 100, then all the excise items. So it was a complete learning process. Service tax, today service tax is such an efficient method of collecting money because it has been a gradual rollout. They never started service tax overnight on all the items. There were first 4, then 12, then 46, then 80, then 100, like that. So you had continuous learning process and it went on. So one suggestion I gave was, which again they are not, seem to have taken note of it. I said that why don't you do one thing, take 3 manufacturing sectors, take 3 trading sectors, implement GST like implementing a software project, find out where are the difficulties you are going to face, and then implement GST. But if you roll out at one go, the country will simply not be able to take the shock of completely migrating from one platform to the other. And the very interesting thing which my colleague Vaidisuran wrote an article was, they issued a circular, the Central Board of Excise and Customs, that if you don't migrate, we will punish you under so-and-so Act, under CGST Act. The tragic irony is that CGST Act has not been passed. It is still a bill. Then when he wrote this blog or something, then they noticed and then they backtracked on that circular. So this is the kind of Alice in Wonderland situation which is going on. So I'll just conclude by saying that my objection to GST is not ideological. What I feel is, be true to what you say. Victor Hugo said, when you speak, define your terms. If you want a GST, implement the GST in the spirit. I would say have a GST with just 10% tax. Believe me, there's a concept in the European Union called flat tax. You just put 11% tax, 15% tax. Lithuania started 11% tax. From 77 tax, they brought it down to 17% and brought it to 11%. So whether you're an individual, partnership, company, trust, whatever, everybody pays a 17% flat tax. No deduction, nothing. On your income, 17%. The collection of tax from 77 to 17% came down. You'll think taxes dropped. Taxes tripled. Right? So the tax you collected, income tax, at the rate of 40% is much more than the tax you collect when it was 97%. So if my other fear, which I may tell you, is, it's very unfortunate. This is not a constitutional part, but I think it's a real situation. If your RNR, you know what's the RNR is revenue neutral rate. Why is it called RNR? Revenue neutral because I'm going to lose excise duty of 16% and I'm going to lose VAT of 12%. So the loss in revenue is 28% on the value of goods. So they say, they started with 27% GST. Now with great difficulty, some sanity has prevailed, it's come down to 18%. Please ask yourself the question, go to any part of India, you and I may be law-abiding citizens, you go and tell them, I want this water bottle, I want this electronic item, I want 18% tax, the first thing the man will say is, I don't want the bill. You're going to have a huge thing of, again, going back to a cash-based society if you're going to have these high rates of tax. When a man pays 12% excise duty, he's paid to the factory. He doesn't bother. When most goods are, you don't pay tax because there's no multi-point tax. You levy tax at the wholesale rate, that works. But if you're going to put GST at every shop which is about 25 lakhs, you're going to have multiple shops of less than 25 lakhs. To give you an example, I gave a shampoo example and I'll conclude. Earlier, shampoo used to have 105% duty because of this socialist philosophy I told you. So what did people do? The duty was up to 5 lakhs, 0% duty. From 5 lakhs to 15 lakhs, 50% duty. And above 15 lakhs turnover, 105% duty on shampoo. Shampoo and all toiletry articles, cosmetics, your creams and so on. Throughout Tamil Nadu and Pondicherry, all your shampoo, that's how this concept of this sachet shampoo came. Household after household had shampoo units which will make shampoo up to 4,95,000. No duty. And it's every large multinational, Hindustan Lever, Cuticura, Ponds, all of them got these things done through small units, no duty. Then the court said, yes, they are all independent units, you can't club their clearances. All are below 5 lakhs. Then what to do? Then in a very intelligent move, what the government said was, okay, if the shampoo is less than 5 lakhs, it doesn't matter. If it is sold with a brand name of a large unit, it will suffer the full duty. So that way it was plugged. I am afraid that if you have exemption of 25 lakhs, you will have Mr. Datar 24 lakhs, Mrs. Datar 24 lakhs, Junior Datar 24 lakhs, Junior Datar 24 lakhs, daughter-in-law 24 lakhs. You will have multiple what is called splitting of entities, and you will have the problem what in taxes law is called clubbing of clearances. So I'll take an order from you and say, go to that small by-lane, there is one shop there, go and collect your goods, his turnover is less than 24 lakhs, no need to pay 18% duty. So friends, I've been talking on and on my topic of the day, which is GST, and I hope that, of course, I tried to speak without any note or anything like that. I just wanted to tell you what are the practical problems from the constitutional part of it, from the practical part of it, and how it may lead to serious problems. We had the shock of demonetization. I don't think the nation can take one more shock. Let us go for it only when we are fully prepared. Now, I think it's 10 minutes for question and answers. Yeah. You can ask me anything on career, on tax, on GST, whatever you want. Yeah.
Good afternoon, sir. My name is Nilav. I'm third year. You mentioned a lot about the practical implications of a GST. I had a more of a constitutional question. So, given all the problems that we're looking at, GST, you mentioned that there is no legislative entry when GST is entered. You have Article 246A. So, you envisage any sort of constitutional...
No, that's not a problem, because it doesn't say that unless mentioned the legislative entry, you can't have a tax. The Constitution gives a power, I can give it in Article 246A. I would have preferred that there was a specific entry on GST which could have been defined, but it is not there. But it is not, I don't think you can any challenge it on that ground, that there is no legislative competence. No, I think, in my view, the way it has been drafted, it is, there is no question of legislative competence, The practical implication, there is a lot of difficulty on how the GST Council has been drafted. There is a lot of problems. Suppose I don't obey the GST Council, what happens? Since you asked the question, for example, center state, Article 131, all of you must have studied, if there is a dispute between center and state, it has to go to the Supreme Court under Article 131. Now the GST Council, very funnily drafted, GST Council consists of Finance Minister, Minister of State for Finance, and all state ministers. This is the GST Council. They decide the dispute. Now, Tamil Nadu may have a dispute with Karnataka on some sales tax issue. So the GST Council, of which both are members, will decide the dispute. And the language used in that 269A is very similar to 131. Now suppose that GST Council decides the dispute. Will I go under Article 136? Will I go under 131? And suppose tomorrow a renegade or a rogue state says, I don't give a damn, this is my law. There's nothing you can do. There's nothing you can do. There's a very big danger because the GST's powers are recommendatory, they're not binding. Anything else?
Going?
Hello. So this is Arpita from the 5th year, and the question pertains to the aspect doctrine and the pith and substance difference. So I agree in the Federation case, the argument that Mr. Palkiwala had used that in pith and substance, it's not an expenditure tax, but a tax on luxuries, could have been used in a similar way by the Attorney General saying that no, it's in pith and substance, it is still an expenditure tax and not a luxury tax. Probably the aspects doctrine, the way it was used there was not needed because essentially they were arguing the same thing. However, if we talk about the tax practitioner's case, I mean, is it your view that there is no way possible that you can tax the service aspect of that particular transaction and that is totally wrong? Or we could have done that case also with the pith and substance doctrine? Wasn't the aspects doctrine needed because, as you said, aspects doctrine is core contract, pith and substance is core the law. So if I say that I have to tax professions, I am only looking at the status at the end of the day, and because this is a principle that you cannot interpret a taxing entry in a liberal manner, I couldn't have included the service aspect into it. So in my opinion, I feel like I would still merit the distinction that they used over there vis-a-vis the aspects doctrine.
Your point has two parts. First of all, Palkiwala didn't argue on pith and substance. Take Federation of Hotel cases. And if you're interested in Federation, that judgment is delivered on 2nd May 1989. And on the same day, your Federation judgment, you have LL Hotels, another hotel company, and the judgments are contradictory by the same bench. That apart. Aspects doctrine was saved. They had to save that particular law. And in the concurring judgment of Ranganathan, he goes on aspect doctrine and says that, look, when you're taxing, they was an expenditure tax. So he said that when I go and spend the money, the argument was, and the room tariff was about 1,000 rupees. So the argument was that when I tax an expensive hotel, a luxury hotel, it amounts to a tax on luxury which comes under entry 62 of the state list, and therefore the central government can't levy what is called an expenditure tax. So that's what. Then they went to the aspect was, when I go to a hotel and spend 1,000 rupees, if I let's say go to Taj or ITC hotel, which is an expensive hotel, no doubt the state government can levy a tax and entry 62 saying it's a luxury tax. Many of you go to a 5-star hotel, you have to pay luxury tax. Now central government is levying expenditure tax on the same amount. According to me, it could not have been done. So they said, no. When I go to Taj and I spend 1,000 rupees, the state government tax on the luxury aspect and the central government taxes on the expenditure aspect, which I am not able to, I don't think it's a correct way of looking at it. So coming to the profession part of it, my argument was, which we lost, taxes on professions, trades and callings. Now, when I say you can tax a profession, like a chartered accountant or a lawyer, you tax not only his enrollment in the bar, but also his carrying on profession. Now, once tax on profession comes, and if you now take the principle of constitutional law, that every entry must be given the widest possible scope. Don't give a narrow construction. All legislative entries, these are fields of legislation, they must be given a very expansive definition. If that is the case, I ask myself the question, if the state government had levied a tax on lawyers and hypothetically there was no limit and they said that, say, depending on your profession, you pay a 2% profession tax, would it be valid or not? In my opinion, it would be perfectly valid because it comes under tax on profession. And I don't understand the difference between the aspect of carrying on a lawyer. I am a lawyer. When I enroll, I pay tax on profession, I pay 2,500 rupees per year. That's the maximum rate in this thing. I think about lawyers, about 10 years I have to pay 2,500 rupees under the Madras City Municipal Corporation Act, whether I practice or not. Whereas in service tax, if I earn 20 crores, I'll pay correspondingly more. If I pay 20 lakhs, I'll pay correspondingly less. I think that it will be wrong to say that there is a aspect on earning and aspect on status, which is wrong. Once I'm a lawyer, I'm rendering a service. Taxes on service have been relegated to the state. Only state can tax it. So there was no need to go into an aspect of service and aspect of this and so on.
If I could then just compare the situation to the manufacturing and sale of good example. So when you say that I am manufacturing something, there's something going outside my factory, excise shall apply. But it's not necessary I sell that, right? I mean, your VAT will apply only when the activity of sale happens. Now, if I make a comparison to that situation, does that comparison stand, or you can say...
No, they don't stand, because I'll tell you why. Now, the point is, what is a taxable event? In the profession tax, the taxable event is a person carrying on a particular profession. If my taxable event is carrying on a profession, then there's only one taxable event, I'm a lawyer. Now to justify a service tax on saying that profession tax is whether or not you practice, service tax is whether or not you practice. Tomorrow service tax, suppose they say that all lawyers shall pay service tax, a minimum service tax of 5,000 rupees per year, even if they don't practice. You can't say it's bad. So that's one thing. Now that excise case is a totally different situation, because you must always ask those of you who want to specialize in tax, the fundamental principle is there is a taxable event. Gift Tax Act, when I make a gift, it's a taxable event. Customs, when I import goods, export goods, taxable event is leaving or entering the territory of a country, customs. So like that excise, the moment I manufacture the goods, I make some new article, I have to pay excise duty. Now what Parliament does is, on how can they pay excise duty? They can say, I'll take your cost of production at 10%, no problems. They can say, if your truck is 10 tons, I'll levy so much. Or they can say, on your selling price, I'll levy duty. That's a measure of tax. So manufacture is a one event, sale is one more event. There are two independent events on which two separate levies are being levied. Take for example, to give an example, income from house property. The very famous case, Buckingham and Carnatic Mills. Income from house property is permitted. That is, comes under entry 82. Tax on land and buildings is entry 49, list 2. Now your corporation, you pay tax on your building. Income house property, you pay tax on the income you get from your rental income. Now they said there are two separate events. Tax on land and building is the very fact that you own the land, I can levy tax on that building. In that concept, they took the view that, look, how to levy tax on a building? I can go by the area, I can go by the locality, I can go by the water parameter. I can also go by the rental value. That's a measure of tax. That's how they saved. They said this is actual earning of the rental income, and this is a tax on the building per se. This is on the income. That's what they said.
Yeah, next question, Rahul. Can you pass on the mic, please? Possibly this should be the last question. We have time till 1:15 only, so by the time sir responds, we should be able to...
I think we go. Fine.
Okay, all right.
Questions. One is again with respect to the aspect theory. My question with respect to the aspect theory is based on one simple premise as to, do you think can there ever exist a situation wherein a tax is on a subject matter and that subject matter is equally falling under both the lists? So you talked about how the aspect theory was incorporated from Canadian constitutional law, and in Canadian constitutional law in subsequent cases they have actually made a distinction between pith and substance and the aspect theory, wherein they have said that both can exist and they apply to separate scenarios. So if, just to give a background before my question, a pith and substance doctrine is wherein a tax falls 90% into one list and 10% only as an incidental encroachment into the other. So it's more or less an exclusive determination. However, subsequent cases where there existed scenarios wherein a tax would equally fall into both the lists. So quantitatively, give an example where it falls 50-50 on both the lists. That's how the Canadian constitutional lawyers have applied the aspect theory. So usually if you use the pith and substance doctrine and it's inconclusive, wherein you can't put it under one particular list, that is how, and only at that stage has the aspect theory been used. So do you think that the pith and substance doctrine as it exists in India has been expanded to such a sense that it's no more a question of exclusive determination? Because then I get that the aspect theory in India will not exist, and I completely agree that the Federation case incorrectly applied the aspect theory. So again, at the cost of repeating, do you think that the pith and substance doctrine is enough to encompass situations where tax and subject matter equally falls under both entries in two different lists? And my second question is a bit general because I'm an aspiring tax litigator, so I couldn't resist this question. What advice do you have for first generation lawyers who want to get into tax?
Yeah. I'll answer the second part later. First, on aspect theory. I'm glad that so much of interest is generated in aspect theory. When I made this aspect theory before Justice Kapadia and I gave a note, to the best of my memory, there is no Canadian aspect theory tax on taxation. First of all, aspect theory is wrong. It's called the double aspect theory.
Double aspect.
Now, as far as the taxation issue is concerned, subject to correction, I don't remember, but all I remember is the cases of non-tax issues which came under the Section 91 of the BNA Act and Section 92 of the BNA Act, and they were equally covered by both fields of legislation. Now, if you see our constitution, and if you're interested, since you're a tax litigator, you must read one judgment which, according partly wrong but partly correct, MPV Sundaram Iyer's case, MPV Sundaram Iyer, 57 Supreme Court, where Justice Venkatram Iyer points out, if you see the scheme of our constitution, you have fields of legislation, entry 1 to 97, list 1. Entry 1 to 81 are general laws. 82 to 96, 95 are tax laws. So you take, for example, entry 41, import and export of goods and laws relating thereto, entry 41. Corresponding taxation is in entry 83, customs. So what Justice Venkatramaya says, our constitution is structured such a way that you have basic subjects and then you have taxing subjects. Similarly, state list, you got entry 1 to so and so, this, and then you got the taxing subjects from entry 44 onwards. This is the structure of the constitution. From the beginning and ending with Godfrey Phillips, with the best discussion on overlapping of taxes is in Godfrey Phillips, where they go into what's a luxury tax and so on. The Supreme Court has said in our constitution, the way the constitution is structured, there can be no overlapping of taxes. So on the same subject matter, you cannot have overlapping of taxes. Now the biggest battle I am fighting today as a tax litigator is overlapping of VAT and service tax. Take for example software. Many state governments have put in their VAT schedule, development of software and sale of software is a goods tax. In the Service Tax Act, they have said that development of software is equally a service. Overlapping of tax on the same item, two taxes are being sought to be levied. That's one of the major problems which GST will solve. One plus point of GST is this overlapping of sales tax and service tax will go. For example, your Tata Sky, right? What happens? It is subject to state tax, entertainment tax, because it comes under entry 62. And if you're interested, the word is entertainments and not entertainment. And there's a huge discussion of what is entertainment vis-a-vis entertainment. It starts from 1688, but that's a different topic. It was called a turnstile tax, entertainments. And the law is, what is going to be taxed are public entertainments, not watching TV inside your house. Right? So anyway, entry 62 is tax on entertainment, list 2. Once, if you say Tata Sky can be taxed by the state government, how do you levy service tax on that? What is the service aspect? So now they say, when I provide movies and contents and so on, that is the service aspect. Switching on this and seeing it in your house is an entertainment aspect. So perhaps my intelligence is limited, but you see what happens is, like my old senior told me, my senior who was a leading tax lawyer, he said the whole difficulty with many people is you first build the bridge and then start finding the river. You see, you decide it's going to be taxable, then you start hunting, how do I justify this tax? Aspect theory, this theory, that theory, and so on and so forth. Pith and substance is simple and clear. If it's pith and substance, if it's entertainment, then only state government can levy. Then whether I watch a movie or watch a cricket match is none of your business. Yeah. Yeah. No, both can answer.
I'm Srijoy Bhattacharya.
No, about your tax thing, I just come for everybody here, sir.
So, sir, I'm Srijoy Bhattacharya from third year. My question is not related to GST, but a different topic that you have spoken on. So, you've always spoken against having company law tribunals. So, could you elaborate on that, and what do you have to say about income tax tribunal which got struck down recently?
Well, just quickly, because we're running out of time, I've been fighting tribunals from 1994, and finally I gave up out of sheer fatigue. So my point is, I say tribunals in my argument with the Supreme Court, and I've repeatedly said that, is that I am not against tribunals. Tribunals are an essential part of the justice delivery system. You require tribunals. Income tax tribunal you must have. GST tribunal you must have. No doubt about it. But my point was, tribunals are basically where the list is between the state and the individual. And the point of law is that if it's a case between two private parties, it should go to the judiciary and not go outside the judiciary. There's a long history of why these tribunals are there. But say, for example, DRT, Debt Recovery Tribunal. It should have gone to civil courts. It can't go. Now, talking of Canada, there's a fantastic judgment called in re residential tenancies. If you can arrange to circulate this judgment, a judgment of 7 judges. In re residential tenancies, in the matter of residential tenancies. In Canada, there were a large number of rent control disputes. So they formed one Green committee by some Mr. Green, who recommended start rent control tribunals, so that judiciary, the standard argument, judiciary is overburdened, highly technical, you go to a simple expert and so on and so forth. So they started rent control tribunals. It went up to the Canadian Supreme Court, and they completely analyzed a 3-stage process. If you're interested, that is discussed in, I argued this National Taxation Tribunal, where we succeeded, they struck it down. Read the concurring judgment of Rohinton Nariman, where he has reproduced my submissions. There, the Canadian Supreme Court said, very beautifully put by Justice Dixon, he said, if there are too many cases, create more courts. That doesn't mean you can take judicial matters and place it outside the judiciary. There's another beautiful judgment of the Australian High Court, which is their Supreme Court. There was a racial discrimination matter that was sent to a tribunal. They struck it down. They said the right, whether a person is discriminated or against, it's a civil right, it's a human right, it can't be decided by anybody but the judiciary. And we succeeded in NTT, National Taxation Tribunal, particularly the Nariman judgment, because our argument on behalf of all the association was, decision on substantial questions of law can only be done by the judiciary if separation of powers is a fundamental part of our basic structure. You can't have decision on substantial questions of law going to tribunals, however intelligent that tribunal member may be. On your, sorry.
Oh, sorry. Thank you, sir, for wonderful insight on the subject. This is Satyan from 4th year. So you also mentioned about the country is not ready to face this second shock after demonetization. I understand there was some problem, but always argument comes from government, and then they try to portray as well that nothing happened, and nothing happened negatively, and the whole it always tries to portray
to justify what they did.
So and there was no uproar as such, visible uproar. There were people who had problems. There were media reportings and all, but if it comes to GST, literally even the small manufacturers whom I personally knew, they are totally unaware of what exactly happening, and they are in the impression that it is going to benefit. Like, what kind of benefit or what kind of additional powers will be given to the officers, assessing officers? Because one of my friends is inspector in central income tax, and he was like, he was clueless. I don't know, that what kind of powers, because he was
sorry.
Seriously, like what kind of
I'll tell you what. See, as far as GST is concerned, now that you decided to implement it, the country must be ready. You either have it at a higher threshold limit, because if you put 25 lakhs, you're going to put very small traders into it. Now coming to your point of demonetization, yes, there were not many protests and so on and so forth. The media said some people died standing in the queue and so on. But I know many cases where there's been a huge loss of income for a number of people, but people have borne it gracefully and stoically and taken it. I just said that, look, in demonetization, you wanted to attack black money, terrorism, and foreign funding, whatever, these, the counterfeit notes. That was three-pronged, black money. No, black money won't be solved by this. Like, see, tomorrow, suppose you say that as of now, all the alcohol which all of us have today will be unfit for drinking from tomorrow. If your aim is to cure alcoholism, you say from today all the alcohol will be unfit, but you keep the liquor shop open and say, I am not sell 1 liter, I'll sell 2 liter bottles of scotch and whiskey. People are going to keep drinking, they're not going to solve the problem. Now, in fact, one person told me, since you're friend of income tax, he said now that man is asking 2,000 rupees as a bribe and I can't ask him for the change. So what I'm paying 1,000, I'm now paying a 2,000 rupee note. So this is a part of the DNA problem, we can't get rid of it. I only mention this because, see, demonetization, we wanted to do something. It's like chemotherapy. See, you want to attack one cell, but you ravage the body. So like that, you wanted to go against three things, but nobody expected this kind of demonetization. In fact, I was talking to a leading person on Calcutta. I had a matter in the Delhi High Court, where he said they could have done two simple things. They could have just put different color notes of 500 and 1,000. And you know what the problem, according to him, I don't know. He said that all the ATMs did not have the software to process 2,000 rupee notes. And that cartridge comes from only one company in China. That's what they told me. So this became a huge problem. So what happens is, you have a wonderful solution, but very often in theory it comes out completely different. Like when I write a book, you plan a particular book, but when you actually go down the line, you go in a completely different way. So GST is very nice, one nation, one tax, very romantic, very nice, but what's happening on the ground? Totally different. Yeah. Now I'll just answer this. Sorry. Three or four to make it work in India. See, I personally feel you should have one tax, whatever it is. Maybe you can just have one exemption for some item, but if the more the rates of tax will go. Secondly, if at all I have to say, it's like saying that you want to lose an arm or a leg, but to answer your question, how will GST work? One is reduce the number of taxes. Secondly, I was thinking is to having this dual control, partly state, partly center, have a GST service, have a body of officers who manage and implement GST all over the country. Take them from the state government, central government, train them to run the GST implementation. Because now what's going to happen is, I don't know if you have seen the papers, I am a large company, more than 1.5 crores. 90% of companies over 1.5 crores will go to the central control. 10% companies with 1.5 crores will go to state control. Now suppose I'm a company having multiple branches, what to do? Nobody knows. In this, in less than 1.5 crores, 50% will go to the state, 50% will go to the center. How do you want to divide it? Nobody knows. It's a compromise formula. So I don't know the answer how GST will work. I first thought that what I gave to the PMO's office was, you implement GST for 20-30 items, see the problems, and then sort it out, because you can't sit and anticipate all the possible problems which will come. Like, who thought in demonetization there'll just be nothing in the market? I mean, so many people lost their job, construction came to a standstill, nobody thought of that. So just to give us a nutshell, one rate of tax or two rates of tax, you don't have the multiple SGST. Secondly, you have one model law which all the states should follow. If they have one standard law, then it's okay. And you must also have a system where states can't give different exemptions to different commodities. If you do that, then you're in a serious problem. Yeah. Now, to answer the question on, not only on for first generation lawyer or second generation lawyer, well, just some bit of advice or suggestions, looking back on what I've done. I personally feel that you must first decide you want to litigate or you want to go into non-litigation work, transactional work. That's one big division. If you decide to litigate, it is my sincere advice that you don't jump into taxation or trademark, etc. immediately. Try to work in a civil office for 6 months or 1 year. Learn the basics of CPC. To give an analogy, if you're going to medicine, my friends' parents who are leading doctors, they said that the fundamental difficulty is people immediately go for specialization in medicine. They felt that they were government doctors for 2 years and then they went into specialization. So the basic knowledge they got of overall medicine was important. Similarly, the basic principle of civil law and CRPC you must know. So my advice to people is, more valuable than any LLM, in my humble opinion, is that learn basics of civil law and criminal law in office for 1 year to 18 months and then go to your specialization. In my life, my colleagues who are specialized in taxation, they still have a difficulty in doing other branches of law. I had the good fortune of doing both branches and then I went into specialization. That has helped me personally. That's my personal view. One thing. Secondly, once you decide to specialize, you have to be a master in that particular subject. There's a gentleman called Jim Cathcart. If you go to YouTube, Jim Cathcart is a lovely video on self-development and so on. And he says mathematically, if you spend 1 hour in your specialization every day, 1 hour per day on your field of specialization, in 5 years you will be the world leader in that particular field. You will have world-class facilities. So once you decide to specialize, try to do as much in your subject as possible. In that line, I would say that one foolproof formula I've seen among all my colleagues who have practiced at the bar is that once you decide to do, say, trademark law or patent law or tax law, whatever it is, try to write as much as you can. Write articles. If you can write a book, nothing. I have not seen a single lawyer who has written a book and not succeeded at the bar. A number of my juniors have written books and they have done very well at the bar. So by writing, what happens is you get a presence, you get known. One other handicap which we have is we can't advertise, right? So there's a very famous English book on advocacy by O.C. Mazengarb. It is in the British Council. I don't know, it's Mazengarb, M-A-Z-E-N-G-R-B. Lovely book on advocacy. Other good book on advocacy is by Lord Macmillan, just called Advocacy. There Mazengarb puts a very, he says, get known, young man, get favorably known if possible, but get known. So it's a cynical way, but what I'm saying is, if you keep writing articles and participating in seminars, giving lectures and so on and so forth, you can do well. I've mentioned about it in my book, that Legal Eagles, that I set a target of writing an article a week, and that's how it helped me in my own practice, because I was also a first generation lawyer. Not only a first generation lawyer, I was in Madras, didn't know a word of Tamil, didn't have anybody, but then it helped. The other thing I would recommend people is, in commercial law, is please try to learn accountancy. I don't know if you got an elective on accountancy. My recommendation to everybody is, you get an edge. Today also what helps me a lot, especially when I'm briefed by chartered accountants and so on and so forth, I'm able to get on their wavelength because I'm also a cost accountant. I did that. Of course you can't stay in Nalsar and do ICW. I don't know if it's correspondence is possible, but please learn accounts. You need not complete ICW or chartered accountancy like I have done. See, very few of us have completed both. Salve is a chartered accountant and this thing. Ganesh is a chartered accountant. Ishwar is a chartered accountant and lawyer. But those of us who in accountancy get a slight edge. Just learn accounts till you understand Schedule 6 of the Companies Act. The old Schedule 6. That is the company balance sheet. If you know that much is enough, I would tell people, join intermediate ACS or ICW, whatever you can. Pass the exam of intermediate, you will learn Schedule 6. That's enough. You know what's a P&L account, what's an income and expenditure account, what's a provision, what's a liability, what's a contingent liability. All these points will help you. So these are all the advice I'll give. And above all, I'll just tell you, just be patient. Just because I find my son also, same thing I keep telling them, everything they want within 2 years. You must get a car in 2 years, you must get a house in 4 years, everything. Life doesn't work that way. Remember Malcolm Gladwell's 10,000 year rule? It took us 10 to 11 years to buy our first car. It took 6 years to buy a typewriter. That's the kind of thing we had. And now at least firms pay very, very fancy salaries. When I joined the bar, I was getting 100 rupees from 80 to 83, 80 to 150 rupees a month. Of course, money went a long way at that time. You got a full meal at 4 rupees, but 150 rupees. And the only way we could supplement was taking classes, teaching and writing. So it was just sheer necessity that forced us. But if you're God blessed enough to have money and get a good senior who pays you well, please don't ignore writing, because see what happens is just sitting and reading is not this, but when you decide to write on GST, you will put some amount of scholarship into it, you will marshal your thoughts, and it will help you a lot. And I'll also conclude one thing. You can take it a biased view. There is no profession like the legal profession, and one of the most wonderful things you can do is to prepare for a case and argue in court. Equally is arguing a difficult case. So join the bar. If you can litigate, nothing like it. Just be patient. All of you basically come to Nalsar. You have got a huge advantage compared to the other students. Just leverage that. Just be patient 5, 7, 10 years. You're going to be practicing for 80, 90 years. at least 70 years. By the way, Jetmalan is 94 and he's still practicing, and he plays badminton every morning, so that's a different one. But there are many lawyers who have finished 50, 60 years, going very strong. So what I'm telling you is don't be in a hurry. Don't take shortcuts. Just be patient. You will, and if you work hard, believe me, I'm not trying to flatter you or encourage you. It is impossible for you to fail if you work systematically and hard in the legal profession. Thank you.